All right, this is part three of chapter 9, our last lecture video for the entire semester. And we're going to start with jury selection. So jury selection is a process. Today we select, in California, we select our jury from people who um, go to DMV and either get an ID or get a driver's license. So that's where we get our jury pool from. So the names are randomly picked by computer. The jury panel lists are generally every 2 weeks. Jurors must be available for at least 2 weeks. Um, the courts are pretty good about not calling you for 1 year after from the time you serve or the time you're called up. And they have a pretty good system now where you can show up for 1 day, and if you're not called, you get you're dismissed. You don't have to sit around for 2 weeks. In the old days, you had to sit at the jury commissioner's office for a 2 week period. So they've changed that. So a court jury trial, 12 jurors is also known as a petite jury. That means 12. Yeah, it has to be, in criminal cases, the verdict has to be unanimous by all 12. So the court determines the size of the jury panel. Oftentimes they will ask the attorneys, how many do you think we need? Because the attorneys know the case. When the judge gets the case, they just see the charges. They don't have any of the evidence in front of them. They don't know how complicated the case is other than what they can figure out from the charges themselves. So they'll look to the attorneys and say, are there any special issues? Like in sexual assault cases, I often would tell the judge, look, my victim is a child, so you're going to need at least 120 to 200 prospective jurors. And that sometimes newer judges that were inexperienced would look at me like I was crazy, and then I would explain to them that because the victim's a child, the percentage of individuals that either have been harmed sexually as a child or know somebody, a family member, is that number is substantially high. So you're going to get a lot of people saying, I don't want to be part of this jury. Okay. So there's certain ways to be excused from a jury. The first one is hardships. Hardships are it's up to the judge to decide on hardships. The attorneys have no say, no comment. We're not allowed to invoke our opinion in any way about hardships. Hardships are the code or the law has a very specific list of hardships. Being a student at school and being a full-time student is not a hardship. Being an employee at a business where you're responsible for a specific job that nobody else can do is not a hardship. Oftentimes we'll get people who are bookkeepers who cut the checks for a small business, and the court will say that's not your hardship. That's the business's hardship. That's not your hardship. The business has to find somebody else to write the checks. You can still stand for this trial. A hardship would be like you may have a medical condition. Let's say you just had a heart attack, and so you're still physically, you're not really capable of sitting in a chair for 8 hours a day. That would be a hardship. A hardship would be if you worked by commission. You didn't work, you didn't get paid, and you have a family to raise and to feed. And so if you're in a jury trial for 2 weeks and you don't get income for 2 weeks, that would be a hardship. So those are up to the court. Challenges for cause are challenges that are made by the attorneys. Attorneys, there's an unlimited number of challenges for cause. You can challenge everybody on the jury if you wish, but you have to show that they have a prejudice, that they can't be fair and impartial. And you have to establish that by asking them questions. And if you're not able to do that, then the court's going to deny your motion to excuse somebody based on cause. Peremptory challenges are very different. You get a set number as an attorney, you get a set number of peremptory challenges based on the type of case that you do. If you do a misdemeanor case, you get 10 peremptory challenges. If you are an attorney and you do a felony trial, you get 10 peremptory challenges. If you're a prosecutor and you're charging two defendants and you're prosecuting both defendants at the same time, each defense attorney gets 10 peremptory challenges. You, the prosecutor, would get 20. So it's a balancing. It's balanced. Whatever the defense gets, the prosecutor gets. You can use these challenges in any way. You can say, you know what? Well, first of all, you don't have to give a reason for excluding somebody. You simply say, Your Honor, I would like to thank and excuse juror number 6. That's it. That's all you have to say. You are not required to provide any reason why you're getting rid of this juror. So I've gotten rid of jurors because they seemed intimidated, and I didn't think they would be willing to speak out in a jury room. I've gotten rid of them because they seemed too aggressive, that they were, kind of loud and pushy. And I'm watching the jury as soon as they walk in the room. I'm watching how they behave, how they interact. Um, I've excused jurors because when the defense attorney gets up and the defense attorney's talking about things, the prospective juror is shaking their head, yes, yes, very good. They're smiling. I get up and talk to the jury, and they don't say anything. They don't move. They don't smile. It's like, well, I don't think they like me, or I don't think they like the government. So out they go. So it can be for a variety of reasons. It can't be based on race. It can't be based on religion. It can't be based on, you know, certain factors. But other than that, you can get rid of them because they're too tall, they're too short, their hair is too long, their hair is too short. You don't like them, you just have a feeling, you can get rid of them. But you only get 10, so you're going to be limited. All right, so the Sixth Amendment requires that each defendant have a speedy trial. So in California, that means that once you get arraigned in a misdemeanor, you have 30 days um, to start your trial. So the government has to start the trial. The burden is on the government for speedy trial rights, not on the defendant. And so the government has to start the trial within 30 days unless the defendant waives that time. Most defendants are going to waive the time because most defense attorneys are not going to be ready in 30 days. For felonies, it's different. You have 60 days from the date of the information arraignment. So there's two arraignments. There's a complaint arraignment and an information arraignment. The complaint arraignment is done at the time that they're first arrested. So the first time you're arrested, the first time you're taken to court, you're going to get a complaint arraignment. And then during that time, you're going to get your preliminary hearing. And then after your preliminary hearing, the DA has to file an information arraignment. And at the point in time when they file the information arraignment and the defendant has a hearing on that arraignment, you've got 60 days. And then, so the speedy trial rights are all through the process. Once you're arrested, the process starts. So here's kind of a breakdown. So on a felony trial, once you're arrested, you got 48 hours to get to the arraignment. And then from the arraignment, you have, so you're at arraignment. And then from the arraignment to the preliminary hearing, 10 days. Then from the preliminary hearing to the information arraignment is 15 calendar days. So there's a 15-day break in between there. And then at the information arraignment is when you have that 60-day time period to, here we go. From here, from the information arraignment to the trial is 60 days. If you fail any one of these timetables, if you're on the 11th day of the preliminary hearing, case gets dismissed. If you miss the arraignment, if you don't file your arraignment papers in time and the person cannot get arraigned in 15 days, the case is dismissed. If for whatever reason, and I mean any reason, you don't get your trial within 60 days, the case gets dismissed. So if the court picks a date as the 60th day, so the court does the math to pick the 60th day, the prosecutor agrees and says, yes, Your Honor, that's the correct date. And the defense attorney agrees, yes, Your Honor, that's the correct date. And then you come to the 60th day and one of the parties figures out, oh, we're on the 61st day. This is wrong. Case gets dismissed. It doesn't matter whether the court made the mistake or you made the mistake. It doesn't matter. If the defendant doesn't get their case done on time, case gets dismissed. The government cannot cause a delay. Prosecutor cannot request a continuance outside the speedy trial rights. Now, the prosecutor can ask for a continuance, but it's going to be very limited. It's going to be the prosecutor's out sick, they have an unavailable witness, but other than that, you're not going to get a continuance. And that unavailable witness, it has to be unavailable for a particular reason. Not every reason allows you to continue the case. Now, the defense can waive at any time. The defense can come in at any time and say, Judge, I'm not ready. We need to continue. And defense attorneys have a lot of latitude. The court's going to give them a lot of freedom on letting them decide when they're ready for trial. But otherwise, the court has to start the trial according to the time frame. And the court has to be actively involved from that last date. So they can't just call the case, put it on the record, and go home. They have to start the process. So failure to start the trial on time results in a dismissal. Okay. So the defendant must request a court trial. Oh, so we're talking about court trials. I already kind of covered this, but we'll go through it real quick. The defendant has to request a court trial. The prosecutor cannot request a court trial, but they have to approve of the court trial. And then the judge, if in a court trial, the judge becomes the judge of the facts and the judge of the law. So now we're on to rules of discovery. So discovery is evidence. Discovery is just a legal term that attorneys use for evidence. So the prosecutor is responsible to preserve any and all physical evidence. If they destroy evidence intentionally, the case can be dismissed. If they are sloppy and irresponsible with the evidence, the case can be dismissed. So in most cases, the defendant will be entitled to a copy of the evidence and have the right to test and retest certain items of evidence. So for instance, if somebody gets arrested with cocaine and the defense attorney wants to do their own test to see if it's cocaine, they're allowed to do that if there's enough drugs available for them to test. Prosecutors are held to a higher standard. This is an important rule. Prosecutors are the only group of attorneys that have a higher standard than defense attorneys and civil attorneys. So prosecutors have an affirmative duty. In other words, prosecutors have to make sure that the defendant's constitutional rights are protected. In a civil trial, the attorneys, their responsibility is to their client. So if I'm representing a client and I have evidence that's going to help the other side, in a civil case, I have no responsibility to give that evidence to the other side. In fact, I have a responsibility not to give it to the other side because it's going to hurt my client. And so in civil cases, my responsibility is solely to my client. In criminal cases, the prosecutor has a responsibility to the government and to the people of the state. They also have a responsibility to the defendant to protect their constitutional rights. So those rights include providing defendant an opportunity to review the prosecutor's evidence. It requires responsibility on the prosecutor to preserve the evidence. And it also requires the prosecutor to provide the defendant with any evidence that would help the defendant in their case. Brady material is just that evidence. The prosecutors have an affirmative duty to provide the defendant with any evidence, information which is favorable to the defendant. Meaning, if the prosecutor has evidence that helps the defendant in their case, the prosecutor better turn it over to the defendant. It gets a little murky if the prosecutor has evidence or has information that isn't quite evidence, but it's information that may help the defendant. And so prosecutors have gotten in trouble in the past when they look at this information and say, well, this is BS evidence or BS information. It's not any good. I'm not going to give it to the defense attorney. And then it turns out later on it was good. So now the prosecutor's in hot water. So it's a really slippery slope for the prosecutor and a huge challenge for DAs throughout the state. Evidence which will assist the defendant in their defense or evidence which may lead to other evidence that may assist in providing the defendant's innocence or prove the defendant's innocence. They're required to provide to the defendant, and they're also responsible. Prosecutors are responsible for any information that's being held by the police as well. So they're responsible for both. So it's a very challenging area of law for prosecutors. All right. So this is it. This is my last video. If you have any questions, please email me. Remember, turn in your outlines, and good luck on your final quiz for Chapter 9. Take care.